legal experts to stop by to discuss the latest on the Trump trials and why rulings and why certain upcoming testimony should concern the Donald.
Intent. The Jenna Ellis tape, it was leaked to the public, and, the squabbling over whether or not it should, that's someone else's problem. I'm glad it was, Jim, because it demonstrates the intent of the boss. And everybody knows the boss was Trump, and everybody now knows the boss had no intent of vacating the White House. They just weren't going to leave. You and what army, right? And she said, but that's not how it works. He said, I paraphrase, but effectively, now it does.
We don't care.
We don't care. Jim, your thoughts about what you've, I'm sure, heard on the greatest radio show ever and perhaps in other media outlets.
Principally through the wonderful broadcasts, including this one of Civic Media, of course. Two things, and you hit on both of them. One is, why is this important? And then we'll do a little law school stuff too, which we often do here on Devil's Advocates, right? The reason is, as you just subtly or perhaps implicitly indicated, what is the intent? If Donald Trump honestly, genuinely believed, which is what his lawyers are sort of advocating or indicating will be his defense, that he genuinely believed the election had been stolen and that this was not about any intent to undermine the process of voting, the counting of the electoral votes on January 6th, those kinds of things, then he doesn't have a good defense, but at least it's arguably within the ambit of something you would argue to a jury here, that what Jenna Ellis and presumably others are saying is, we told him expressly that he had lost, and he told us effectively that doesn't matter. That's not my consideration. He wasn't fighting with him about what he'd lost or not. He was basically saying, I am staying in power. It is not at all about my vindication of some justice-related or democracy-related issue having to do with the future of our republic. It's all about me, and that goes to the intent. That's why it's such a damning piece of evidence. Presumably, she'll testify about that during the trial. And here's the law school part of this, and it's the other piece that I suspect people will revel in. Yes, this is Jenna Ellis, who is there in the room talking directly to the defendant, which is the key here. She is now a cooperating witness. She will take the stand and she will say, that person, Donald Trump, who's sitting right there at counsel table, told me these things. You might say, well, gee, that's hearsay. How does that come in? The answer is, it does come in. It is not hearsay, believe it or not, because under the rules, you're talking about statements attributed to a party opponent. This is the defendant whose words are coming out of this other person. And you can describe it, if you will, colloquially as an exception to the hearsay principle. It comes in, and everybody knows that. And that's why this particular rendition from Jenna Ellis, and presumably others, will be a part of the trial whenever it happens in Georgia. Another topic. But it will come in, and it is completely inculpating when it comes to that intent issue. This is not good news for Donald Trump at all.
Funny Willis says this trial will not end before the election. She says it will drag into 2025. Our understanding, Lena Habas, the attorney for Trump, the Eileen Cannon, she's giving every indication she might be in the tank for Trump. So I have less confidence that trial's going forward, and that probably offers the clearest evidence. I mean, he's seemingly so guilty of this. We've seen the photos, Jim.
Right.
But the Jack Smith, the J6, the crimes perhaps alleged and perhaps soon to be proven against the former president. I'm putting all my hope in this trial because this is the big enchilada, Jim. This is the underlying crime as far as I'm concerned. The evidence we've seen, the Jenna Ellis tape, does Jack Smith get to utilize this evidence as well or call her as a witness? And do you expect he will?
Right. And that is the question here. Again, this is just speculation. The reality is that, again, the so-called the insurrection trial, the January 6th, the voting trial, scheduled to go in the District of Columbia in March, just as the election, the campaign is ramping up at the same period of time. Interestingly, almost the same time as the New York hush money case in Manhattan is also scheduled. So lots of things happening in March. of this coming year. But absolutely, the law enforcement can and does routinely share evidence. Would be interesting to know, and we've talked about this before on this very good broadcast, whether or not, and I assume they are, that the attorneys who are representing the Jenna Ellises and the Ken Chesbros and the Sidney Powells and the Scott Halls of the world have also got to be chatting, I assume, with the federal authorities. And I was actually sort of surprised that they cut a deal on the state system and the state prosecution without wrapping up something there. Now, they're not charged. They're not charged in the federal case. And Jack Smith has some discretion there. But presumably, at least some of those folks we know are on the list of the unindicted co-conspirators in that case going to trial in March, the January 6th federal case. And so highly likely that there is some communication among the attorneys there, including the investigators and the prosecutors themselves. They don't have to coordinate amongst each other, especially since we've got a federal case and a state case. Some of them indicated even that we know each other, we talk from time to time, but we're not coordinating. They don't have to do that, but nothing prevents them from sharing that sort of thing. And there may be some agreements about the uses to which some of these tapes, these recordings are provided. But you have to believe, once again, that Jack Smith, even though he is equally outraged by the release of these tapes into the public domain, is also recording all of them and can, in fact, in that trial, in the January 6th trial in the federal court, he can call these witnesses himself and also elicit from them the testimony that are also providing now in the state system, whether that's a cooperation situation, whether that is compelled testimony. They could also, of course, invoke the Fifth Amendment. Curious because they're already waiving their Fifth Amendment in the state case. Lots and lots of issues here. The short answer is yes, this can be a part of a federal presentation too, as well as the state case going ahead at some time later this year and into 2025. I agree with you. The January 6th one coming up sooner. Donald Trump, the singular defendant, 4 counts in that case. We're focusing on him and his conduct. We don't have to deal with other defendants in that case. It's just that focus on what he did and those 4 very, very compelling counts set forth in that very, very compelling talking indictment that we've also chatted about in the past.